Hello everybody. The paper I wrote for the book was looking at the decision of the Delhi High Court in a case called Nas Foundation versus NCR Delhi, and the case was really about the decriminalization of homosexuality in the Indian context. And the importance of the case was not just that it decriminalized homosexuality, but the reason it decriminalized homosexuality. The reason the Delhi High Court decriminalized homosexuality was because the Delhi High Court felt that decriminalization of homosexuality was really in tune or in touch with the deepest constitutional traditions. If there's an idea of inclusivity which is at the heart of the Indian Constitution, then decriminalization would be an imperative. Similarly, if the idea that you don't discriminate against minorities based on who they are is a part of the Indian Constitution, then homosexuality would have to be decriminalized. That was the line the Delhi High Court took. And in line with the theme of the book, the chapter focused upon the idea of the Indian Constitution as a transformative constitution, which is that the Delhi High Court really drew upon a deeper constitutional history and tradition to make the argument that homosexuality is not an offense in the Indian context. The other interesting thing of the Delhi High Court judgment was that it really drew upon an international or a global jurisprudence as well. They drew upon the jurisprudence in particular of South Africa and the decision of the South African court in the context of decriminalization of homosexuality, and they also drew upon the jurisprudence of many other countries in the global south. All this is very good as a great indicator of the potential of transformative constitutionalism, but in the end of the day, for a constitution to be transformative, it really depends upon the people who interpret the constitution. And while the Delhi High Court did an excellent job of understanding the fact that the root of decriminalization really lies in the words of the founding fathers of the Indian Constitution, be it either Dr. Ambedkar or be it Jawaharlal Nehru, the Supreme Court, unfortunately, on December 11th, 2013, took a very different stand. The Supreme Court overruled the decision which we talked about for so long, which is the Delhi High Court decision, and basically held that Section 377 of the Indian Penal Code, which criminalized homosexual expression, continues to be valid as per their logic and reasoning. And I think I just want to just maybe end or look at just two small points, which is while the transformative constitutionalisms have potential, how they can fail if judges do not have the constitutional spirit and thinking within them itself. And just to make 2 points on why the Supreme Court failed in this case and why in some sense the paper which we wrote is really a gesture towards the future. It's really something which we hope will come back again and become a part of the future of Indian constitutionalism, though it's not now the present, since the decision has been explicitly and overruled by the Supreme Court in the decision called Suresh Kumar Kaushal. And Suresh Kumar Kaushal, the decision, has been called by one of India's well-known novelists as a bad day for law and love. It's a bad day for love. I think all of you will understand why it's a bad day for love. Because very simply, if you say that a certain community has no right to express themselves in terms of their intimate attachments, in terms of the person they might choose to love, quite obviously prima facie, on the face of it, it's a bad day for love. But I want to take you through why the decision is a bad day for law. And I think this links up once again to the heart of this project, which is the idea of the transformative constitution. Because I think the judgment, in effect, does not understand or does not appreciate the fact that the Indian Constitution is a transformative constitution. What the judgment says is they use one particular line. They say that since the lesbian, gay, bisexual, transgender population is a minuscule minority, they're not entitled to challenge the constitutional validity of section 377 of the Indian Penal Code. And I think this one line is indicative of a deep failure of the Supreme Court to appreciate what the Indian Constitution is all about. Because put very simply, the idea that there is a numerical bar you need to cross to access rights is deeply inimical to the Indian constitutional tradition, to the Indian Constitution's understanding. If you look at Article 14 or Article 19 or Article 21, if you look at any of the rights under the Indian Constitution, there's nowhere does it lay down that a small minority or minuscule minority is not entitled to all the rights. And that is the failure. The second huge failure of the court to appreciate its own role is when they make the point that in this case we defer to the legislature. They make the point that we defer to the legislature because in their opinion the issue of LGBT rights is best adjudicated, or the issue of the constitutionality of this law is best adjudicated by the legislature. Let the legislature pass a law and repeal if they choose to, was the line they took. Again, that embodies a very deep failure of your understanding of the role of the Constitution. Because in a diverse and plural country such as India, where there are majorities and minorities of many stripes and hues, if you leave the minority at the mercy of a majoritarian institution like Parliament, then it can be very possible that most minorities in India would have had no rights today. So the role of the Supreme Court has really been, as the court itself has acknowledged, as the custodian of the Constitution. And in this case, they have explicitly said that we will defer to the legislature, thereby abdicating our role and responsibility as the custodian of the Constitution and a role and responsibility to protect the rights of all minorities in this country. So in a sense, this judgment is a really bad day for law, mainly because of the fact that they fail to understand that the crux, the heart, the spirit of the Indian Constitution. So where do we go from here? Where do we take this from here? I'll just end with one last thought, which is to say that I think the project is a very relevant and a very important project. I still think though the decision which we spoke about so much in this book has been overruled, it still represents a very important part of how a court can choose to apply a constitutional thinking to its decisions. And it still illustrates what the role of the court should be. That the role of a court in a diverse and plural nation which is based on hierarchies of many kinds is really to ensure that the court plays the role of protecting the rights of all minorities. So I think the hope is that in the future, in the time going forward, that this decision will be explicitly overruled by the Supreme Court through a larger bench, in which the Supreme Court will take very clearly its constitutional role and obligation, will also understand very clearly the fact that the best thinking really evolves when you're able to pay attention to decisions around the world, when you're able to appreciate the fact what Brazil has done, what South Africa has done, what other countries around the world have done. When you assimilate that to your own constitutional thinking, marry that to your own constitutional tradition, and come out with a new way of thinking. And that, I think, is the hope of the future, and I think I'll just end with that. Thank you.